And we continue to follow the court's other major decision today, the rejection of affirmative action programs in college admissions. Tia is in Studio 32 with reaction.
That's right, Anthony and Natalie. The Supreme Court says colleges and universities can no longer take race into consideration as a specific basis for granting admission, a landmark decision that upends long-standing precedent that has benefited Black and Latino students in higher education. And joining me now to delve into this controversial topic is political science professor Stephen Caliendo from North Central College. It's always a pleasure to have you here breaking this all down. Thanks for being with us.
Thanks, Tia. It's nice to see you.
So let's talk about this. Is there anything that can be done in terms of this decision? Is this actually all now set in stone?
Well, I mean, I think one of the things we learned as we study the court is that precedents can be overturned. As you mentioned in your lead-in, there have been several cases since 1978 about affirmative action that have upheld the ability of colleges and universities in particular to use race as one of many criteria to help rectify past injustices and to diversify their incoming classes. The court's saying today that that's not appropriate, it's not constitutional, and so colleges and universities will have to think about other ways to achieve those goals.
So we know in terms of what the justices decided, they were looking at Harvard University and also the school in North Carolina. Can you talk about exactly what those cases were all about?
Well, I mean, I think it's important that we remember, too, Tia, that affirmative action in college and university admissions is really used only at the most elite schools, the most competitive schools to get into. And so most colleges and universities, while they may have diversity goals and try to bring in a diverse class on a number of factors, not only race and ethnicity, it's really the elite private schools and the flagship public institutions that use it. And so, you know, what's been happening for years is that while lots of things are considered when you apply to college, factoring in race was allowed to be, and in fact encouraged to be in a lot of ways, just one of those elements to consider. The court's saying today that taking race into account in any way, even if it's designed to rectify past wrongs, is not constitutional.
Now, was there any portion of this opinion from the Chief Justice that seemed unclear to you?
Yes. You know, the Chief Justice Roberts was very clear some years ago when he authored the opinion that struck down part of the Voting Rights Act, Section 4 of the Voting Rights Act, that he thought we were past racism in America for the most part, that we didn't have to think about it anymore, that the legacy of slavery and Jim Crow, et cetera, ought not come to bear on current events. But then, just a couple of weeks ago, he authored an opinion in a similar case, a voting rights case about redistricting, where he seemed to have had some growth and to understand that those legacies still exist. What we saw today, though, was very similar to what he had written before, in saying that we we can't take it into consideration. I think what's left that's unclear for me, though, Tia, is that the majority is saying you can take race into account if it's part of a student's essay where they discuss how their race is part of their character and how they've developed, et cetera, but that you can't just have a box that awards some points in a formula, for instance, for race. And so there's some nuance there that I think colleges and universities at these elite schools are going to have to wrestle with in the coming days and weeks.
Okay, a lot of people agree with you on that. Stephen Caliendo, professor of political science at North Central College. It's always a pleasure to have you breaking down these issues. Thank you for being here.
Thanks, Tia.